Hello, everybody, and welcome to History/Law Bite number 152, dated January 6th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Youngstown Sheet and Tube Co. versus Sawyer, 343 U.S. 579, 1952. The Youngstown Sheet and Tube Co. versus Sawyer decision, sometimes referred to as the Seizure Case by those in the know, was a very important one in American constitutional law. This landmark decision by the U.S. Supreme Court dealt with the issue of the limitations and reaches of non-enumerated executive power under the Constitution, most specifically with respect to private property during wartime. All right? And before we get into the details, let's review some context first. Again, this decision was handed down in 1952 when the United States of America was actively involved in the Korean War. That war lasted from 1950 to 1953. Harry Truman was the president of the United States at the time, number 33. And if you know anything about President Truman, you know that he was a very get-her-done type of guy. All right, he didn't play, he didn't pull any punches, he did what he said, okay? He said what he did, all right? He meant what he said, and he said what he meant as well, okay? So, President Truman, all right, in acting as a responsible executive, had to prosecute this war, successfully. And knowing what we know about war, it is essential to keep the means of production moving without any interruption. Interruptions can create states of national emergency, all right? So that is what we face here in Youngstown Sheet and Tube Co. versus Sawyer. In this case, due to a perceived strike between many steel mills in the country and the large union, the United Steelworkers of America, President Truman issued an executive order, all right, in 1952, authorizing his Secretary of Commerce, Charles Sawyer, to seize control of the nation's steel mills, all right, placing them under the authority of the U.S. government, ensuring that the means of production of steel would continue unabated. Interestingly enough, the United Steelworkers of America supported this move, but of course the steel companies weren't about to take this lying down, all right? So they immediately challenged President Truman's actions in the courts, all right? And after some back and forth in the U.S. District Court and the U.S. Court of Appeals, all right, the matter was appealed to the Supreme Court of the United States, all right? The court was faced with a simple question, and that was, did the President of the United States, outside of any specifically enumerated authority under Article 2 of the Constitution or any authorization from Congress, did the President have the authority to seize control of the nation's steel mills via an executive order? All right? In a 6-3 decision, the Supreme Court said no. No way, no how. In an opinion written by Justice Hugo Black, in taking his normal absolutist stance, not just on this, but many other issues, Black held that the President of the United States, outside of any enumerated power in the Constitution or any authorization from Congress, did not have any power to implement the seizure of these steel mills. Essentially, he had operated outside the scope of his authority. Okay, the President did not have the authority to make the law here and take the steel mills under the possession of the federal government. All right? President could not assume a congressional role and legislate here. Okay? Black's taking a very solid absolutist opinion. Now, 5 associate justices joined Black in his majority opinion all concurred, all right? Separate concurrences agreeing with the outcome, but with slight variances with respect to Black's absolutist stance here. Justice William O. Douglas wrote a concurrence that was more or less almost a mirror of Black's absolutist opinion, though with his own nuances to it, of course. Justice Felix Frankfurter refused to go along with the belief that the president had absolutely no power here to do this in cases of national emergency, but conceded that, under certain circumstances, the president may indeed have the authority to do this when the situation required it, most especially if Congress declared war, all right, which was not the case in Korea. For the record, we did not declare war when we went to war in Korea, all right? Justice Robert Jackson, all right, wrote perhaps the most powerful concurrence here in the Steele seizure case, where he outlined a 3-point strategy for determining executive power. That concurrence has been cited many times, all right, in subsequent cases when executive power is examined by the court itself, okay? Jackson's concurrence, outlined areas where executive power was essentially clearly stated in the Constitution, all right, where executive power could happen if Congress was essentially silent, or where the president was specifically defying Congress, all right? 3 separate spheres, all right, that do not overlap, okay? So Jackson certainly went to work with his majority opinion, and his concurrence, and the remaining 2 concurrences written by Justices Burton and Clark, all right, pretty much went along the lines of Justice Frankfurter's, that, while the present case, President Truman had acted unconstitutionally, there could indeed be instances where, in matters of national security or national emergency, the president could indeed issue such a seizure of private property if, the health and viability and the security of the country depended upon it, most especially if we were, like I said, in a declared war, if we were invaded or something like that, or being bombed, the president of the United States would certainly have such authority to protect the nation, even if Congress did not act first, okay? So Black's fellow justices who went along with his judgment per se certainly had their own opinions with respect to the scope of executive power. They all agreed on one specific point, that the current action by President Truman was unconstitutional. But the other 5 certainly disagreed, at least in part, with Black's absolutist stance, and certainly left the door open for, executive power to be able to seize private property during wartime, in certain matters of national emergency. They didn't want to foreclose that ability of the executive because obviously, and quite logically, the president is in a far better position to protect the nation's interests than Congress. One man is certainly far more effective than 535, okay? So they logically left that door open in future matters where the president could indeed act. All right. And those concurrences, serve obviously to tell the Black opinion that, we agree with this, but, it's certainly logical and, legally possible in our view for the president to have this authority in other situations. All right. So that was the majority and concurring opinions. All right. So the decision also drew a dissent from Chief Justice Fred Vinson, who was joined by Justices Stan Reed and Sherman Minton. These 3 felt that the majority was entirely wrong in their logic that Truman's action was unconstitutional, and they cited various instances in history where the President of the United States had indeed acted and seized various types of private property without specific and direct authorization from Congress. All right? For the record, I'll add that Chief Justice Vinson, who was appointed Chief Justice by President Truman in 1946, never, ever ruled against the actions of his dear friend. All right. So just wanted to point that out. So once again, the holding of the court, majority opinion by Black, was that the President of the United States did not have the inherent authority outside of any specific enumerated power under Article 2 of the Constitution or a direct authorization from Congress to seize private property. All right. In order to seize private property, as was done by President Truman here in this case, he would have had to have had specific authority from Article 2 of the Constitution or direct authorization, statutory authority from the Congress. As neither was the case, President Truman's action was declared unconstitutional. All right. And again, this case has been cited in other cases involving executive power. All right. Now, a little bit of history attached to this decision. Justice Hugo Black, who of course wrote the majority opinion in this case, hosted a dinner not long after this decision was handed down, in which he invited all of his fellow justices as well as President Truman. Back during that time period, the president and Supreme Court justices were a whole lot closer than what they are now. That didn't violate any protocol much in the 1940s, 50s. So, it is what it is. But, and all showed up. And you can imagine, when President Truman arrived, the atmosphere was probably a little tense. President Truman was certainly salty about the court's decision, and he could hold a grudge, but as I've read and seen that, after some dinner and some libation, the atmosphere certainly lightened up quite a bit. And President Truman is rumored to have told Justice Black, and I quote, Hugo, your law is no good, but your bourbon sure as heck is. I can certainly imagine President Truman saying something like that. So that, folks, is the Youngstown Sheet and Tube Co. versus Sawyer case, 343 U.S. 579, 1952, an Article 2 case on the subject of presidential power outside, all right, of authority from the Constitution or from direct authorization from Congress. All right. So from this case, severe limits were placed on the executive to operate when he did not have specifically enumerated authority from Article 2 of the Constitution or specific statutory authority from Congress when it came to seizing private property. All right. It just happened to be a war going on. And so it was a matter, in the eyes of President Truman, one of national emergency. All right. Personally, I would have filed a joint Chief Justice Vinson's dissent in this case, as I personally feel that in matters of national emergency, the executive certainly has the inherent power to act, even when they do not have specifically enumerated authority from Article 2 of the Constitution or specific statutory authority from Congress. Okay, so again, Youngstown Sheet and Tube Co. versus Sawyer, 343 U.S. 579, 1952, the Steel Seizure Case. If you have any questions or controversies, please leave them down below. I'll be happy to answer them. If you have not subscribed to my channel, please just hit that little red subscribe button and that little bell, and we'll be in business. Thank you so much again for listening. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.